Mr. Joshua Raj Thomas.
Madam Deputy Speaker, I declare my interests as President of the Security Association Singapore and a member of the Board of Directors of a security company. At the outset, Madam, I would like to register my strong and wholehearted support for the bill. The bill introduces two key amendments. First, 3 new offences will be enacted to protect security officers while they are executing their duties. And second, it will no longer be required for security consultants to be licensed under the Act. By way of background to the first set of amendments, the Security Industry Associations and Union had lobbied MHA for some years to consider amending the Protection from Harassment Act, or POHA, to include security officers in the definition of public service officers. This had also been raised by Mr. Patrick Tay in this House, as well as Mr. Zainal Sapari. So clearly, the stakeholders were delighted when MHA suggested that we instead introduce protections for security officers under the PSIA. The new Section 17A to 17C will make it offences to assault, hurt, or harass security officers whilst they are carrying out their duties. Section 17D provides for circumstances where enhanced penalties may apply. What is significant is that the penalties prescribed in each section are higher than that stipulated for similar offences under the POHA. This is an important recognition that it is particularly egregious to harass or to assault or to hurt a security officer while he is carrying out his functions, because the role that he plays is essential and critical to the orderly functioning of society. To a certain extent, these provisions are corollary to the amendments made to the private security industry conduct regulations in 2019. Those amendments introduced penalties, including fines and jail terms for security officers caught being remiss in the conduct of their duties. The rationale for those amendments was to hold security officers up to a high level of conduct if they were remiss while on duty precisely because of their critical functions. It is therefore fair and fitting that even as we underscore with those amendments the importance of security officers' duties, that we also move the current amendments to afford greater protections for them. The urgency for these new provisions is apparent. The Union of Security Employees and the Singapore University of Social Sciences conducted 2 surveys that have been referred to by several speakers today. Madam, the findings are nothing short of appalling. Last year's findings showed that a third of security officers faced abuse. And this year's findings found that the frequency had increased to 40%, with the increase being attributed to the greater role that security officers were required to undertake due to the pandemic measures. Older officers were found to face abuse on a more frequent basis. The media has reported on specific cases. MOS mentioned in his speech the incident in 2019 where Mr. Andrew Lim, a security supervisor at Roxy Square, was punched in the face by one steward, Boyd Mills. Madam, the footage of the incident is chilling. The sheer force of the punch knocked SS Andrew to the ground. Mills was later convicted and sentenced to a week's jail under POHA. In another even more unfortunate incident, 74-year-old security officer Chu Chu Chien caught and reprimanded one Teo Chin Lai for urinating behind a door of a Bukit Panjang shopping centre. Teo punched S.O. Chu in the chest and S.O. Chu fell backwards and suffered injury to his cervical spine. Sadly, S.O. Chu died from his injuries 6 weeks later. Of course, causing grievous hurt, as it is in this case, is not part of the amendments to the PSIA and will still fall under the penal code. But my point is that security officers, as frontline workers and as enforcers of rules, are often subject to physical abuse, which has caused injury and has even been fatal on occasion. As regards incidents of verbal abuse and harassment, these are abundant, and a simple search on Google will pull up numerous media articles, videos, and accounts of such behavior. Madam, I have often found it ironic that the security officer's uniform, ostensibly a symbol of authority, has instead become looked at by members of the public as a lightning rod for abuse. Today's amendments will change this. So I would like to say to all our security officers, your uniform, your PLRD ID are now symbols of the protection that you now have. In the course of your duties, if you are verbally abused, if you are harassed, assaulted or hurt, you are now protected by law. So carry out your duties proudly, responsibly, professionally, and if you are subject to any form of abuse, report it and action will be taken. And there are various ways for reporting to be done. As these are now statutory offences, ultimately at some point, the abused officer will have to make a police report. But as mentioned by several speakers earlier, the Union of Security Employees is rolling out an easy-to-use app where officers can now report abuse that they have faced, and they can seek advice on how to proceed to commence the process. The app will be launched by the end of the year. Madam, there are also other initiatives to uplift the wages and working conditions of our security officers. Chief amongst these are the progressive wage model that the Security Tripartite Cluster will announce soon. Another important initiative was launched by SMS Zaki Mohammed in July this year, the Security Industry, Workplace Safety and Health Guidelines, which was drafted by a committee co-chaired by SAS and USC. Third, MOM also launched the Work Care Grant in May this year, which was mentioned by members earlier. And these initiatives go a long way to build workplaces and working conditions that are reasonable, fair, and that empower officers to do their best at work. However, madam, given that the nature of the industry is one of an outsourced service, there is another dimension to the exploitation of security officers that has been unaddressed for decades, and which may well be the most prevalent and yet also perhaps the most insidious and difficult to tackle. Current legislation looks at protecting employees vis-à-vis their employers. However, security officers are engaged not to work at their employer's offices, but to work at a third party's premises to provide specific services. The services that are to be provided and the incumbent terms and conditions are therefore the subject of a separate service contract between the security agency and the security buyer. Often, where a service buyer engages a managing agent to manage its site, these service contracts are proposed by the managing agent based on the existing templates. The problem arises because many of these service contracts contain clauses that directly affect security officers' employment and employability. SES recently called out some of these discriminatory and unfair clauses in a tender document that was put out by managing agent Seville's Property Management on behalf of its client Hillview Heights Condominium. We identified 3 specific clauses of concern: an immediate removal clause allowing the managing agent to essentially summarily dismiss security officers, a clause that appeared to discriminate on race, and a clause that appeared to discriminate on age. But these types of contractual stipulations, madam, are in fact not only found in security contracts, but also in other outsourced services contracts, and are actually quite ubiquitous. I do not exaggerate when I say that most, if not all, outsourced services contracts contain some form of discriminatory clauses or immediate removal clauses. These are accompanied with unfettered discretion given to managing agents or security buyers to decide to reject officers deployed to a site or to demand that they be removed immediately. So, madam, many officers apply for security officer jobs based on particular sites or locales. This is because, given that they work 12-hour shifts, they prefer to have a work site near their home so that they can reduce their commuting time to as low as possible. So imagine, madam, when that officer arrives at site and is told that he has been rejected and no reason needs to be given to him. Or he is told that he has been rejected after working at a site for some time, again, with no reason needing to be provided to him. An employer, madam, would not be able to do that. There are processes that need to be abided by for such summary dismissal. But the managing agents and buyers have been able to do this with impunity. Madam, it bears reading out an immediate removal clause ad verbatim to illustrate to the House the truly awesome powers that buyers and managing agents have over the employment and employability of security officers, and I quote, I start my quote here. The MCST or its appointed managing agent shall be at liberty to require the contractor to remove forthwith from the estate any person employed by the contractor who, in the opinion of the MCST or its appointed managing agent, has misconducted himself or is incompetent and or negligent in the performance of his duties and whose employment is considered by the MCST or its appointed managing agent to be undesirable. As can be seen, madam, the right to dismiss is absolute, it is arbitrary, with no due process or right of appeal or review. These types of clauses, therefore, empower managing agents and buyers to hold security officers and other outsourced workers at site in terrorem, or in terror, in fear. Officers who are beholden to these managing agents are often asked to take on non-security functions, which they do carry out because of the fear that they may be dismissed by the managing agent if they refuse. The USC has called this out many times before, giving the examples of security officers being asked on a routine basis to buy food for managing agents, clear notice boards, or clean animal poo. Member Yip Hon Weng also mentioned earlier some other examples of errands that officers are asked to perform. All of these are quite clearly not security functions under the PSIA and are unlikely to be services that the officers or the security agencies contracted to do in the first place. Madam, I had raised this lacuna of application of the Fair Employment and Fair Consideration guidelines last year with MOM and TAFEP. While we agreed that there was indeed a gap and that something ought to be done, the recent announcement that the TAFEP guidelines would be enshrined in legislation now provides an ideal platform for these issues to be addressed as well. In this regard, I urge that MOM includes in the new legislation measures that prevent managing agents and buyers from demanding the immediate removal of outsourced workers at site. That if they do request a change, that they are required to provide reasons in writing, and that there should be a mechanism for appeal and review against such requests. Of course, discriminatory stipulations in service contracts like those on age, gender, and race should also be proscribed by the new law and should not be allowed in outsourced services tender documents and service contracts. Separately, I was happy to read that pursuant to our feedback to TAFEP, that TAFEP had strongly recommended to MOM to review the offending managing agent's work pass privileges. In this regard, I am heartened that there is current recourse for security officers and security agencies subject to unfair and discriminatory clauses in that they can head to TAFEP for assistance. I thank TAFEP for its proactiveness in acting to address unfair practices and to protect our officers. MOM has also confirmed in the Minister's written answer to Ms. Cheng Li Hui's PQ yesterday that investigations are ongoing against the managing agent and that MOM takes a serious view of workplace discrimination. In addition to this, I would also like to urge security agencies not to just accept any contractual terms just to secure a contract, especially when these terms are detrimental to our officers. Agencies that merely chase contracts without regard for the working conditions of security officers on the ground and how they are treated by managing agents and buyers will ultimately gain the reputation as poor employers and will not be able to attract good or eventually any officers. I would also like to urge security agencies that are responsible and that reject such unfair contracts to publicly declare their commitment to fair employment and fair consideration in outsourced services contracts. This will make it easier for our security officers to identify responsible employers and to shun security agencies that sacrifice the welfare and dignity of their officers for the sake of just getting more business. Industry needs to be committed and to work together to make things better for our officers. The status quo is unacceptable. Security agencies need to do our part to clean up our own industry, to wipe out unfair employment practices and unfair working conditions, and to end the exploitation of our officers. Madam, I will move on now to speak about the removal of the requirement for security consultants to be licensed under the PSIA. And I hope that I will be able to address some of the questions and concerns raised by, in particular, Member Mariam Jaafar. Again, Madam, I had been intimately involved in initiatives surrounding this amendment. MOS had mentioned that security consultants will now be encouraged to seek accreditation under the Security Consultants Accreditation Program, or SCAP, which I chair. By way of background, the SCAP was formed pursuant to an MOU between MHA, the Association of Certified Security Agencies, and the SAS. The SCAP adopted the structure of SAS's long-running Certified Security Professional certification, which SAS discontinued in favor of SCAP. SCAP also adopted the existing Continuous Professional Development Framework, which aims to ensure that accredited persons remain current and well acquainted with developments in the industry, in particular with regards to emerging and evolving technologies. In order for a consultant to be able to renew his accreditation, he would need to meet the CPD requirements for the previous year. In order to further ensure professionalism and standards, as well as give the public an avenue to report errant consultants, the SCAP board will introduce a code of conduct to guide how consultants should carry out their work, including ethical considerations. As I mentioned, I chair the SCAP board, which also includes representatives from the other Security Trade Association, SUSS, the Security Industry Institute, and experienced security consultants. MHA and the SPF's Center for Protective Security attends as observers, and the board consults closely with them on all decisions. Admission is either by experience or by experience and passing an examination. To directly address member Mariam Jafar's concern about standards, the examination is set and marked by the SPF. In the first examination that was held in July, we had a 1/3 failure rate, so the bar is set very high, and intentionally so because we only want truly competent and qualified persons to be accredited. To date, the board has accredited 17 consultants. There are 10 persons who have applied as of today for the next examination scheduled in December 2021. And we expect to accredit around 50 to 70 consultants by the end of next year. Most importantly, the removal of security consultants from a statutory licensing regime in favor of an industry-led initiative is an important move towards self-regulation for this particular profession. This ensures that the security consultants profession develops in a manner that is relevant to the industry and to clients' needs without unnecessary government bureaucracy and administration. As president of SAS, I am thankful for the trust and confidence that MHA has in the industry to allow us to lead this self-regulation, and I assure members of this House that industry will step up and that industry will do well. Hopefully this can serve as an example, a model, and perhaps an inspiration for other industries to self-regulate in appropriate areas. What then is the role that security consultants play in the transformation of the security industry? It is important to note that the development of a security consultant's core is one pillar out of 4 pillars in the security industry transformation map. And as members know, and as mentioned by member Fahmi Aliman, one of the biggest drives in the PWM sector is to move away from headcount-based contracts to outcome-based contracts. In headcount-based contracts, buyers stipulate the numbers of security officers they require, and in outcome-based contracts, buyers stipulate only the expected outcomes and leave it to vendors to propose solutions that optimize manpower and technology resources. In order for a vendor to propose such holistic solutions, it would first need to conduct a security risk assessment, and the person who carries this out is the security consultant. There are, of course, many benefits to outcome-based contracts, more efficient and effective security solutions, job redesign for security officers, as well as the possibility to move towards more reasonable working hours and a fairer contracting regime. This is why outcome-based contracts are, in and of themselves, another pillar of the industry transformation map. But in order to make that move towards outcome-based contracts, we need to have a core of security consultants to carry out the first steps. Madam, next year, SAS will launch an online-based tender generator and repository called OBX, which will provide an easy-to-use platform that will help security buyers make that jump to outcome-based contracting. We are glad to have gotten strong support from the SPF and Enterprise Singapore for this initiative, but we will also need to ensure that as this platform provides that big push towards OBCs, that there is a sufficient number of consultants to service these new contracts. In this regard, SCAP is working hard to accredit consultants and ensure that they have a high level of competence and the technical expertise to provide the best holistic solutions to clients. Madam, please allow me to conclude by coming back to the amendments introducing protections for security officers. In my maiden speech earlier this year, I urged that we make it a priority to ensure that all our workers have a working environment that affords them respect and dignity. I urge that we take steps to make sure that we take care of those who take care of us. The amendments introduced today will go a long way to bring us towards that aspiration. Madam Deputy Speaker, I support the bill. Thank you.